Let's move off.
That the court does not send us away empty-handed with its own officer because this is his home most of the time.
But seek, Your Worship, but trace it together with the laws of Uganda guiding applications of this nature, Your Worship. With the key principle, Your Worship, which is the presumption of innocence, guiding all courts of judicature in hearings of applications of this matter, where the accused has all the rights available to innocent people in the country once further guidance is sought. Your Worship, pursuant to the Constitution bail guidelines, in brackets, for all courts of judicature, bail guidelines, Your Worship, in brackets, for all courts of judicature, in brackets, Your Worship, practice direction, directions 2022, practice directions 2022, Your Worship, legal notice number 8 of 2022, legal notice number 8, Your Worship, of 2022, which were cited and fortified in approval, Your Worship, and the High Court miscellaneous application number 28, High Court miscellaneous application number 28 of 2022, Your Worship. That is the case of Bagira Julius versus Uganda. Your Worship, by your land brother, Shs2b Wagona. That applications of this nature have a lot of regard to the antecedents cited by my land colleague, but in addition, the stage at which the matter is. Your Worship, this matter is at a stage where prosecution has adumbrated before this court that they are only investigating. Your Worship, it is at a level of investigations. Our client, Your Worship, has no record anywhere in the courts of judicature in Uganda, of having disrespected any terms for court bail, and Your Worship, in addition and finally, courts are enjoined to guard themselves against being used as tools of scandalmongering, Your Worship. Your Worship, I say this as an office of this honorable court. We have numerous and severally found material trials of this nature against very high-ranking officials in the country, Your Worship. Against very high-ranking officials in this country, where courts are being used as tools of scandalmongering, ballyhoo, and only intended at the appearance for plea taking, and matters are abandoned before courts of law immediately afterwards. Your Worship, we have not had, and of course this is not a stage at which the merits shall be entered into. One would show for the country that this is nothing but a mere travesty, Your Worship, calculated to malign the otherwise hard-won historical credit of our client, professionally, business-wise, social standing, and as a member and the nominee of the intergovernmental organization with great repute. Your Worship, it is in this regard that us, as officers of court, make this application to implore that court exercises the privilege granted under the laws of Uganda to consider the antecedents provided and the grounds of the application, including the witnesses. Surely it is your Worship. And grant freedoms to the accused for purposes that we shall continue to be before you, Your Honor, as and when practically required to do so. I beg to
stated that this is a case of dragging a rat into the sewer. The accused person has complied with the investigation at all times. He complied with the police officers when they required him to appear to the police. As demonstrated by the state, that the investigations are complete, that shows that he's not a flight risk. He would have run away if he found that this was a serious case. It is our considered submission that the accused person is not a flight risk. He does not fear the trial. And we are ready to defend this matter even if it starts tomorrow or right after here the bail application. And we therefore pray that the court exercises its discretion and constitutional obligation to grant the applicant bail. We are aware that the charges claim of colossal sums of money that allegedly was obtained. The accused is ready to defend himself against those allegations. And all court has to do at the moment is to do a balancing act, which it normally does, and give a benefit of doubt to the accused person. We will pray this application will be granted, and I yield back on that.
Yeah, say something about that.
First, that purported affidavit is not filed formally in court for reliance by court. Documents on record do not pass in that format, particularly since it is an affidavit. Documents, like an affidavit, you file it and then you rely on it. You serve and you rely on it.
Yeah, you say again. You say documents on record.
Documents like affidavits in nature are not passed casually from the bar, the bar to the bench. And if they intended to rely on it when we came, if they had filed it, they serve us and we respond. But nonetheless, we will respond because we find that there is a material contradiction. First, this court has been told that the inquiries are complete. The investigations are complete and we are going to leave here with the date for hearing. The same state cannot, in a space of 2 minutes, turn and bring another affidavit purporting to say that inquiries are not complete. It's a contradiction. Your Worship, allegations of interference are not allegations that you make lightly. The courts in this country have pronounced themselves on such allegations. Starting from the notorious case of Panju versus R. When you also read the bail application of Uganda versus Akbar Godin, the courts are saying that such allegations must be substantiated. They are not to be taken lightly, otherwise the sky will be the limit and the court will not envisage when bail will be granted. And Your Worship, the accused and the applicant before you as an officer of court knows that any acts of interference can lead to cancellation of bail if it's granted. He knows. The state is also at liberty to indicate that this man is interfering, cancel that bail. The state is at liberty. Your Worship, at this stage there is no connection between A1 and A2, between the accused and the A2 being mentioned. There's no connection whatsoever. The court in hearing this application must weigh him as a person. Does he merit himself as a person? I also want you to take note, Your Worship, that his credibility and antecedents have not been attacked. I also ask court to consider that the capacity of these sureties to ensure his attendance in court has also not been attacked. They therefore remain substantial. The duty of court in a bail application is to weigh whether this accused, if he is released on bail, will he turn up or he will not turn up. If you are convinced that from what we have presented he will turn up, we ask you to grant him bail. Don't send him home empty-handed. He has already been in custody for 3 days. And he is going through health challenges which I was asked not to go into. That is why even the doctor rushed to see if we can see him. So we are asking that you be pleased to find merit in this application. And then finally from me, bail aside if the inquiries are complete, as stated, we are asking that the disclosures be made immediately. Be pleased also to make an order of disclosure. We are also saying that the case against the accused is entitled to be tried as a person. So the absence of A2 or those others should not be used to delay his trial. The court can survive. If the other one's still at large, in other words, we don't want to come here, A2 is not there, and yet they are injuring and damaging the reputation of a man. We will be ready to try. Because from our interaction with him, his conscience is clear. So we are asking that you make an order of disclosure, and since inquiries are complete in the main file, you also fix a date for hearing. We will be ready to proceed. So we are asking that you humbly consider that.
This affidavit has not indicated to this honorable court how the detention of A1 is a procedure for the arrest of A2. It has not given details of how he's continued the detention. is the best procedure for the arrest of A2. Your Worship, arrests are canvassed well in the, under the Criminal Procedure Code Act. And there is nowhere where unaccused is the arresting entity by detention.
And there's no,
Where unaccused is presumed the arresting entity through detention of the same of a co-accused, Your Worship. Your Worship, therefore, we find that this affidavit is not sufficient to vitiate the discretion of this court. It's not sufficient to vitiate the discretion available to this court to grant bail as applied for, Your Worship. Continue to reiterate the application. What you like.
court shall study the application. I'll also go through the submissions as well as the documentation which has been presented. The ruling was bail on the 6th of November this year. Meanwhile, the first person is remanded into custody till then. Court is adjourned.